I have a very interesting topic for you today. It's regarding self-defense in Canada and what is reasonable force. That's a vexing and interesting question, and there's a lot of gray area about how much force you can use to defend yourself when you're being attacked or there's a threat of attack. So first of all, we have to look to Section 34 of the Criminal Code for the answers to this, and the case law, of course, that interprets it. The bottom line, though, if I am being attacked or threatened as well, but I'm being physically attacked, I'm allowed to defend myself. I'm allowed to protect myself or another person who's being attacked as long as I act reasonably in the circumstances. That's the basics, the gist of a law when you really boil it down to. And you have to use reasonable force. I mean, you can't use excessive force beyond self-defense where you're seeking vengeance on the person. And the criminal code under Section 34(2), it talks about a lot of examples, like how we assess the reasonableness of your actions. A lot of it's common sense. Did you act reasonably in the circumstances? Now, I want to take a look at Section 34(2) and go through each factor. I've got my criminal code here. So the first thing we have to look at in assessing reasonableness is the nature of the force or threat. Let's give you an example. So let's say a gun's being used against you, and you have to defend yourself. Well, certainly you using a gun back would be reasonable force, there's no question, or a knife, for example, to defend yourself. You're about to be shot. Whereas, let's say you're in a bar and a person's grabbing you. Does it make sense you pull out a knife or a gun? No, obviously that's not reasonable. The second factor is the extent to which the force was imminent, meaning is it happening right then and there? We can't have someone punch us in the face and then go attack them 5 minutes later and call that self-defense. In the same factor, were there other means available to respond to the incident other than the use of force? That's a factor that can be considered as well. What was your role in the incident? What's the other person's role? Maybe you were the aggressor and you promoted this, and the optics of it are not going to be good for the judge. You don't just start pulling out a gun in a fist fight. Did the other person use a weapon? Obviously, if another person has a gun or a weapon, you can respond proportionally. You need to defend yourself or you're going to die or get seriously hurt. The size, age, and gender and physical capabilities of the parties are important. If you got Mike Tyson at his peak in a bar and some guy pushes him on the shoulder and threatens Mike Tyson, do you really think he has imminent fear and needs to start attacking the guy? No, he could probably just deal with it another way, let's face it. So gender and size are very important factors to consider. We've got to look at the nature of the relationship between the people. There may be prior threats leading up to that night, which cause fear, which can prompt a situation, so you have to look at that as well. And we have to look at the communication that night. There may have been various threats that night which cause fear, where you need to protect yourself, and leading up to an ultimate threat. Don't forget, you can defend yourself from a threat too. A person may be in just front of you and waving a gun at you or waving his or her fist in your face. How do you respond to that? Your proportional response. Now, the next factor is a very important one. This is a key one. The nature and proportionality of your response. Proportionality. Do we respond in a bar to a push with a gun? No. A knife? No. Do we respond maybe with a push back and stepping back yourself and creating some distance? Yes. You've got to apply common sense here. And finally, the final factor is whether you knew that the person had lawful authority to assault you. For example, let's say you were an officer is telling you to submit to an arrest. Well, you can't start saying that's in self-defense. So a lot of common sense applies to proportionality, and there's a lot of gray area. I've defended a lot of these cases over the years, and I'm going to give you some examples of what may or may not be excessive force, and let's go to the bar situation, because that's a lot of cases I've defended are in bars. So let's say you're at the bar and you're just standing there minding your own business. You're with your girlfriend or significant other, and someone gets in an argument with you and they start pushing you and you really have no place to go and they grab you. Well, stabbing them with a knife, obviously pretty serious. You can't do that. You can't shoot them. Could you grab them? Yes. And prevent them from doing this? Yes. If they started punching you, could you punch them? Yes. Next step. Let's say the threats ended. Let's say they punched you and you punched them and now they're down on the ground and you can get away and there's no problem. They don't have a weapon. Well, you can't sit there and start hammering away on them. Maybe they're unconscious. That's excessive force. It's not reasonable in the circumstances. Another situation might be, let's say, a person pulls a gun on you and you happen to have a gun on you, even though that's illegal. Well, you'd be able to defend yourself. You might be charged with other crimes, possession of a restricted firearm, carrying a concealed firearm. That carries its own weight, but it certainly doesn't carry a life sentence. So like if the guy's threatening to shoot you, you could shoot them. That's a proportional response. Much like a knife situation. Person pulls a knife on you, if you happen to have a gun, you could probably use a gun to defend yourself in that situation. But again, you could be facing other charges if you don't have a license to carry a gun. Very few people do, by the way, in Canada. We're not the States. So reasonable force, it's an interesting concept. It's something, we know it when we see it. The Crown has to prove beyond a reasonable doubt in court, if you're charged with a crime, if you're defending yourself, that you did not act in self-defense. So it has to prove excessive force, for example. I mean, I've defended cases before where the Crown was arguing excessive force, but let's face it, you know, first of all, there's case law that says you don't have to weigh to the nicety your blows. I mean, this guy's punching me in the face with this force, so I can only use this force. No, you can punch, and it might result in a serious injury, even accidentally. That's still not a crime. You're acting in self-defense. You might even push a person if they die. By, you know, people fall and hit their head. That's happened before too. That's still reasonable as long as it's proportional and you're acting in self-defense and everything's reasonable. It's a lot of common sense. I've argued these in front of juries and judges, and they seem to make the right decision about whether it's reasonable or not and proportional. Every case is different, of course. So I've just given you some examples. I'll give you another example of a case I once defended that kind of puts it all together. A fairly recent case, which we won. Fellows at a party, and there was a guy at the party being drunk and acting like an idiot. He was telling people he had a gun, and you know, I've got a gun at the party, and kind of acting threatening. And everyone was kind of scared of this guy because he was a bit of a hoodlum type person, looking at the party and threatening everyone. And at the end of the night, he was removed from the party, but started punching people at the party. And my client, who fairly physical guy, he was concerned about the other people because a couple of women got punched by this drunk, but he didn't want to intervene. But he actually wound up going outside because he knew he was a capable fighter, my client, but he didn't want to get involved because he'd heard the guy had a gun. Now the guy's outside, and my client just told him to leave, and he's still threatening people, and they're standing about 5-6 feet apart at the time. And the other guy goes like this, makes a motion with his finger and starts to reach for his waistband. And my client, knowing that he threatened to have a gun and knowing this action, closed the gap immediately and punched him very hard in the face, shattered his jaw into bits. We won that case going away. It was a very clear case of self-defense. It was proportional. He thought the guy had a gun, and he was entitled to react in the way he did. There's an example of proportional force. If my client was a criminal in that instance, could he have pulled out a gun? Well, that's another issue, but certainly the punch, maybe not. That's a different set of facts, but certainly the reacting the way he did to a person who was threatening to use a gun on him was totally proportional. Every case is different, a lot of factors. Fortunately, the Parliament has changed the laws in about 2012-ish. They simplified Section 34.1 and 34.2. It used to be so complicated, it boggled the mind. Every time I did a self-defense case, restudy the law, get it straight, be able to explain it to the jury. It was so complicated. Juries never understood it. It's much more simple now. There's still some complications, obviously, but everyone struggles with, first, are we reacting in self-defense for the purpose of protecting ourselves, either from punches or a threat? Threats too, by the way, of violence can promote you to do in self-defense. And is it reasonable in the circumstances, which is a lot of common sense. And judges seem to get the right decisions in most cases, and I find that our jury system is very good. People get it. They know when something's excessive. They know when person's exacted vengeance. A guy gives me a slap in the face and I start punching the heck out of him. He's unconscious on the floor. We know it when we see it. We don't need some lawyer pontificating to us what the law is about weighing to the nicety of the blows. There's another famous dictum about weighing to the nicety. It's from an old English case, and it's an interesting case. It's detached reflection in the face of an uplifted knife is difficult to achieve, basically, right? You've got a knife flashing at you. You're not sitting there going, oh, I better analyze this. I better weigh my knife. Do I pull out my knife? No, you react. The adrenaline's going in that moment. You have fear, and you're entitled to react, and you're entitled to react proportionally. Take care of the issue, defend yourself, and move on. One thing I will say to you guys, especially all the males out there and younger males, try and walk away from these incidents. There's often a way to get out. I mean, someone pushes you, leave your ego at home. One of two things is going to happen. I guarantee it. You're going to get hurt, they're going to get hurt, and someone's going to get charged, and it's probably going to be you if you think you're a tough guy. So you need to walk away, leave your ego, check it at home. If you want to get into fighting, join MMA or something legally in the gym. The people I know who engage in martial arts and MMA, they're very disciplined. They don't get in fights. It seems to be a lot of wahoos at the bars who get in fights. Don't do that. Anyway, there's a little bit primer on you know, how you can protect yourself or someone else as well as getting attacked. You're allowed to use proportional force to protect them. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.